afternoon, everybody. Welcome to this panel. My name is Una Fitzgerald. I am an artist, a senior fellow with the Human Rights Research and Education Centre at the University of Ottawa, and a director of the Canadian branch of the International Law Association. I am also the editor of CIGI's newest book, Corporate Citizen: New Perspectives on the Globalized Rule of Law, which explores the legal frameworks and standards of conduct for multinational corporations. Today's virtual event is co-hosted by the Centre for International Governance Innovation, CIGI, and the University of Ottawa's Human Rights Research and Education Centre. Before we begin, I would like to acknowledge that CIGI sits on the traditional territory of the neutral Anishinaabe and Haudenosaunee peoples. CIGI is situated on the Haldimand Tract, the land promised to the Six Nations that includes 10 kilometers on each side of the Grand River. We also acknowledge the location of the University of Ottawa and its Human Rights Research and Education Centre on the traditional and unceded territory of the Algonquin Nation. As this is a virtual event, you may be joining us from another traditional territory, and I encourage you to do some research to learn more about the land on which you live, work, and play. Today's session provides an update on the work being undertaken by key international organizations such as UNCITRAL, UNCTAD, and ICSID, and international investment arbitration centers to address the growing concern of the public sector, civil society, and Indigenous communities about investor-state dispute settlement. Expert panelists will discuss progress and pitfalls in recent arbitration awards and in this policy review process. They will consider the reactions of the investor-state arbitration community to government interventions in national economies aimed at shifting to a low-carbon economy and slowing the spread of COVID-19. They will consider the future pathway for reform. We'll be taking audience questions via the Q&A function in Zoom. Please submit your questions by hitting the Q&A button at the bottom of your screen and typing them in. You can submit your questions at any time during the presentation, and we will do our best to answer as many as possible. So let me take a few minutes just to introduce the book, Corporate Citizen. Domestic corporate law and international trade and investment law have served as the handmaidens to globalization, facilitating the growth of global supply chains and the rise of multinational corporations with operations all around the world. These laws encourage foreign investment and provide financial benefits and legal protections for these global corporate citizens. The objective of encouraging foreign investment is to foster economic development, but international investment agreements are not necessarily well designed to hold corporations to account for the human rights, labor, or environmental impacts of their foreign operations. Nor are domestic corporate law regimes sufficiently robust to address the corporation's conduct outside of its home jurisdiction. In recent years, there has been growing concern at the international, national, and grassroots level about whether international investment law can meaningfully contribute to achieving the 2030 Sustainable Development Goals and other important related goals, such as the implementation of the UN Declaration on the Rights of Indigenous Peoples. We wrote Corporate Citizen to examine the role of the multinational corporation in today's global economy and to explain how domestic and international law could be strengthened to encourage the development of consistent and enhanced standards of human rights, labor, and environmental conduct in economic activities. The book examines the modern multinational corporation from many different angles and in a diversity of voices, written by experts in international economic law, corporate law, investment law, Indigenous law, and human rights. The chapters of this book examine how domestic and international laws shape corporations' freedom to operate globally. The book is arranged in 5 parts. First, it discusses how legal frameworks are straining at the boundaries to address the challenges presented by multinational corporations. Second, the book looks at how different accountability frameworks are taking shape. Third, it discusses whether corporate conduct sufficiently reflects evolving societal values. Fourth, the book examines how foreign investor obligations are gradually starting to come into focus. Corporate Citizen concludes by examining how institutions are beginning to articulate a tentative vision of transnational justice applicable to multinational corporations. As we are finalizing the book, the Supreme Court of Canada rendered its decision in Nevson Resources and Araya, providing an interesting hint to us as to what transnational justice might mean. This year, the pandemic has highlighted the interconnectedness and interdependence of global economic, environmental, health, and justice systems. By examining the complexities of the multinational corporation in international law and governance, the book presents the possibility of corporate law reform that strives to align our human need for economic security with our need for justice and human rights, public health, and a healthy natural environment. The session today will provide deep insights into the future of international investment law and reform initiatives in this context. So to learn more about Corporate Citizen or to order it, please click on the link shared at the chat function below. Now, it is my enormous pleasure to introduce to you the moderator of today's session, Meg Kinnear. Meg is a former colleague of mine from the Department of Justice Canada, but currently she serves as a vice president of the World Bank Group and the Secretary General of the International Center for Settlement of Investment Disputes, or ICSID. So welcome to Meg.
Thank you, Una. I wanted to just set some context for this discussion. As many of you probably know, in the last 20 or so years, there's been a debate about the availability of international investment obligations, and especially the availability of investor-state dispute settlement and arbitration to enforce those obligations. And I think it's fair to say there have probably been about 3 layers to that discussion. The first is one that's at a broad policy level, and in part it talks about whether investor-state and investment obligations meet the economic goals that are promised. And secondly, it talks about whether this regime would be effective to meet non-economic goals, things like human rights, Indigenous rights, climate rights, labor standards, those kinds of other issues. The second aspect of the debate has looked more at the content of international investment agreements and their substantive obligations. So things like expropriation and the extent to which government can regulate for the public good without compensating, the impact of corruption, the failure to comply with domestic law, and those kinds of things that are often brought up in the course of these cases. And a number of states have incorporated changes that reflect this in their new treaties. As well, UNCTAD, a part of the United Nations, has done a lot of work in doing a model treaty that tries to incorporate sustainable investment obligations and incorporate some of the results of this debate. The third basket of changes that I think you can see now is about the framework of dispute settlement. And it looks both to the architecture of dispute settlement and as well to some of the procedure. So in this context, you get discussions, for example, about whether arbitration or a classic court model as proposed by the EU would be useful. You get a discussion about whether mediation holds promise for resolving this kind of dispute. And you get a discussion about increased transparency of the process. And a lot of those reform discussions have been at UNCITRAL, especially in working groups 2 and 3, and at ICSID. The result has been, frankly, prescriptions that are all over the map, from those who would abandon investor-state altogether to those who would suggest expanding investment obligations and investor-state dispute settlement to incorporate goals such as health, welfare, human rights, and climate goals. So there are certainly no shortage of topics for today, and we're extremely lucky to have an incredible panel, and I'd like to introduce you to them. I will not go through their CVs in detail because I'm sure you know of and know many of them, and we will give you written copies of the CVs if you'd like to take a look. But if I may quickly introduce them, we have Justice Ian Binnie, and Justice Binnie is a former Supreme Court of Canada justice and has done a number of investor-state cases as an arbitrator, so he's very well familiar with the area. Next, Charles-Emmanuel Côté from Laval University is a professor there and an expert in this area and has written a tremendous chapter on denial of benefits in this text. So I'd strongly encourage you to take a look at it when you get your copy of the text. Next, we have Phil Fontaine, who is currently a special advisor to the Royal Bank of Canada and a former 3-term chief of the Assembly of First Nations. Finally, we have Penelope Simons from the University of Ottawa and Anthony Van Duzer from the University of Ottawa. And again, Penelope and Anthony have written a tremendous chapter on incorporating human rights into investor-state mechanisms, especially for extractive industries. And again, I'd highly commend that chapter to you when you get your copy of the text. So those are our panelists for today. And we have a few questions that we are going to speak to, but we highly encourage all of your questions and comments as we go through the process today. So let me start with the broad and overall question, which is, do you think international investment treaties and investor-state arbitration are the right tools to achieve objectives such as human rights, climate change, labor, public health strategies, Indigenous rights, and those kinds of other not strictly economic rights? And let me start with Justice Binnie to hear his views.
Former justice, I don't want to involve disreputability on the part of the court. I think, yes, in theory, investment treaties can be a vehicle for achieving all kinds of objectives, economic and otherwise, but it's a bargain as to who needs the investment and who is prepared to comply with the obligations. In the NAFTA, you smack a treaty. Of course, it was used to impose certain labor standards on Mexico. So from time to time, these treaties are useful vehicles. But I think you have to be very practical about the forces at play. You know, most Canadian outward bound investment is probably in the mining sector, the extractive sector. And they are very much against Canada requiring their compliance with Canadian standards or even diluted Canadian standards in foreign jurisdictions. And I imagine we'll get to that in due course. From the vantage point of the recipient countries, the host countries, I think many of them are desperate for investment, and they're not about to make life difficult for companies that are prepared to put money into their economies. I worked for a time in Tanzania. I don't know who else on the call has worked in the third world, but I worked for the Treasury in Tanzania 50 years ago. But the basic problems haven't changed. I was negotiating treaty investments with foreign companies. One of them was Hilton Hotels, and I made expressed some concerns about labor rates and so on. And they said, "Look, Mr. Binnie, Tanzania needs Hilton Hotels more than Hilton Hotels needs Tanzania, period. So take it or leave it." I think up to date, I was in Tanzania a couple of years ago on the Masai Mara mine, owned indirectly largely by Barrick at the time, Canadian company. Massive human rights abuses. I mean, a terrible situation. Physical beatings, alleged murders. There are two sides to the story, but it was a very bad situation. The government of Tanzania was not remotely interested. We couldn't get the police interested. We couldn't get the local magistrates interested. So far as they're concerned, Masai Mara mine was money in the bank, and that was the bottom line. So, yes, these are potential vehicles to achieve desirable objectives. But of course, the other thing is that these countries resent having what they see as Western values, our priority of the environment may not be their priority. So that they see these arbitrators, generally old white guys from Europe or North America. I mean, and Meg has done a tremendous job to try to diversify the arbitrator pool, but it is still a problem. So that there is this cultural issue, a cultural dimension of using investment as a lever to enforce our values on places that may not share them.
Thank you. Charles-Emmanuel, what's your thought on this?
Well, I think we have to ask ourselves some preliminary questions when thinking about that. Are we talking about a problem of lack of effective domestic standard on human rights, environmental protection, labor rights? Are we talking about a lack of governmental will, as Justice Binnie referred to apply effectively these kind of domestic standards? Or are we talking about a lack of international effective standards in this arena that would be binding on corporations effectively? Or are we talking about investment substantive protection rules that are too broad and encroach too much on other international standards that may not be taken into account in ISDS? So I think the question is more complex, and it can be addressed in different angles. And I think the answer might be as complex as a question. It might be answered on these different levels. And so the problem has to be assessed adequately in order to have a correct answer. And I cannot help, and the second thought that I had when I was thinking about that was this current debate about trying to solve a lot of problems in investment treaties, existing and dramatic and real, concrete, serious problems, of course, is for me a little bit reminiscent of the debates that were going on in the end of the 90s and early 2000s regarding the World Trade Organization. And at that time, a lot of pressure was put on the system so that we solve basically every problem almost raised by globalization through the World Trade Organization. And one of the reasons for that was probably the fact that at the time, at least at that time, the dispute settlement mechanism of the WTO was certainly one of the most effective existing in the interstate dispute settlement landscape. And probably, we probably witness a little bit of the same here. One of the reasons of this pressure on investment treaties now is the fact that we have a quite effective investor-state dispute settlement mechanism that is quite unique in the landscape. And this time we have, as opposed to the WTO, we have private parties that may benefit from this system, and they are not really held accountable in that system to respect other kind of rules that are outside of the realm of investment law. So the pressure on the system is derived by probably the effectiveness of the system. But I would like, with the WTO, with experience, we realized that we could not solve every problems raised by globalization through the WTO. And I would think that we can probably not solve everything through enhanced obligations or mechanism in investment treaties. And I think attention has to be given to other areas as well, and not only in investment agreements.
Yeah, interesting. Mr. Fontaine, what are your thoughts on this?
Pleased to be here, and I wanted to note with real appreciation the land acknowledgement before we started our proceedings. Whenever there's a discussion around the issue of treaties, whether we're talking about the matter before the panel or our traditional state, when we talk about treaties and Canada, mean, we haven't fared all that well in that regard, and Canada has been forced to contend with these matters for far too long, and the resolution of these matters are taking forever, and the cost is borne by our side. I'm talking Indigenous here, or First Nations, and so this is a matter that is completely, and I think I'm on good ground to say, a completely new experience, and so we have to really try and get up to speed very quickly, and so we noticed, though, in our short experience with this, that those matters that are of greatest interest to us, the things that matter to us, like human rights, climate change, Indigenous rights and interests, these are considered moral issues. They're not considered as part of the investor relations decision-making apparatus. And as a result, we're shortchanged because we're not part of this game where very important decisions are being taken to advance whatever interest may be at play. And those interests quite often don't include the interests of Indigenous peoples. And so we have a bit of a challenge there. But what I've noticed in the last number of years, and I noted this the last time we talked, there has been a paradigm shift. At one time, we didn't care, or at least it appeared we didn't care about the language we used, the attitude we brought to the table. We didn't talk about things in a business-like way. We didn't talk about joint ventures, equity, and the like. But that has become now the language, and corporate interests don't have a real appreciation where that is coming from our side. And so there's a real education effort that has to go into making sure that there's some balance in the way we relate to each other. And so that's I think an interesting challenge for all of us.
Exactly. Professor Van Duzer.
Well, thanks very much, Meg. I'm very pleased to have been invited to participate here today. In answer to the question, are international investment treaties and investor-state arbitration the right tools to achieve objectives such as human rights, climate change, labor, and public health standards? I think it's important to take a historical note and recognize that in their original design, and I think it's still true today, investment treaties are not they're not designed to achieve or even accommodate these sorts of objectives. I mean, historically, beginning in the 1960s, capital exporting states from Europe were negotiating these treaties in an effort to protect their investors in newly independent developing countries, and their concerns were that the domestic legal regimes in these countries were provided inadequate protection against predatory activities by states like expropriation. And regardless of what the domestic standards were, the domestic institutions in which those standards could be enforced, the domestic courts, were not places you wanted to go because they were not independent from the state, not competent, or perhaps in the worst cases, corrupt. And so treaties were drafted by developed countries with an overwhelming emphasis on very broad investor protection standards. And even though the protection standards applied legally to both parties, the European country and the developing country, in fact, the developed countries who dominated the negotiations were not concerned about how broad or strong these commitments were, because they never expected to have to honor them themselves, because they didn't expect that there would be any developing country investors who would be able to do so. So I think it's important to recognize that both the motivation and the consequent design of these treaties was, and still to a great extent is, dominated entirely by concerns about investor protection. And of course, times have changed. The international community has strongly embraced other values, including sustainable development, the protection of the environment, the protection of human rights, Indigenous rights, corporate social responsibility, and so on. And so I mean, I think one of the key challenges going forward is really to ensure how it is that investment treaties are really integrated with and compatible with these values. And I think one of the key concerns in that regard is that we need to ensure that investment treaty protections do not get in the way of state efforts to try to regulate, to promote the achievement of these widely shared goals in the international community. And it is potentially a problem because the way in which these goals are achieved is through domestic regulation. And so when you have domestic regulatory initiatives and those have impacts on foreign investors, you create a location in which there is a significant potential for conflict between, on the one hand, the investor protection standards and the achievement of these goals. And so while I don't in any way disagree with Charles Emmanuel's point that we need to continually think about other places in which these goals can be achieved, and certainly we're not going to achieve them all through modifications to investment treaties, I think one of the key things we need to do is make sure that investment treaties don't get in the way. And I think we are seeing certainly some changes in this regard, and I think Canada in some ways has played a leading role in the development of new formulations of standards and new ways of drafting investment treaty provisions that are more compatible with these kinds of interests. But I think we need to do quite a bit more in that regard. And we also have the problem in the international investment law area of legacy treaties. And we have thousands of treaties that are out there that don't reflect this sort of more contemporary thinking about the way in which we need to ensure compatibility between investment obligations and these other goals. I think also, and I'll just close with this, we need to think more about ways in which we can reimagine investment treaties as positively contributing to sustainable development, corporate social responsibility, and Indigenous rights protection, and so on, and not just thinking about them in a negative way to try to, to ensure that they don't, directly impede efforts to achieve those goals.
Yeah, thank you. And Professor Simons, what are your thoughts?
Well, thanks very much, Meg, and also just thanks to you and the organizers for having me here today to speak. I'd say I very much agree with what Tony just said about these treaties. They're not meant to be, I think even the reforms that are going on now, they're not meant to solve all the problems of globalization. They're not meant to, changing them up is not meant to be a panacea. But they are part of the problem, and they do need to be reformed to ensure that they don't undermine the ability of states to respect and protect human rights. But also, we have to ensure that they're not actually, contributing to the problem of corporate impunity. There's this widely recognized problem in the international legal system that corporations can engage in transnational business activity that violates human rights or causes harm to the environment, often with complete impunity. And it's not something that can be solved by each state at the domestic level or within the international human rights system. We have this highly fragmented international legal system. All these areas of law, they operate in these silos, and there are very few mechanisms, if any, really, to deal with the kind of overlapping impacts of one or the other. And corporate impunity is deeply rooted in the biased structure of the international legal system, and investment law is implicated in this. So investment law does not simply affect investors in host states, as Tony was pointing out, but these treaties can contribute to corporate investor impunity, host state inaction in the face of human rights violations that have been perpetrated in relation to an investment, as well as the problem of access to justice for individuals and communities that are affected by business activity. And they do so in a few well-known ways. I mean, Charles Emmanuel pointed out that there are these very broad standards, and these standards of investor protection have been interpreted in surprising and inconsistent and even incoherent ways that make it very hard for states to predict what their obligations are under IIAs and what they're supposed to do in order to stay in line with these IIAs. So it creates a perception of restricted regulatory space, as well as there being a restriction of regulatory space. And then also affected communities and individuals that are harmed by the investment are not party to ISDS proceedings, even though an investor might engage in an illegal activity that violates their human rights and the actions of a state that may run afoul of an IIA may have been undertaken with the purpose, either in whole or in part, to address investor conduct. The other thing is that investors are increasingly resorting to investor-state dispute settlement. And there's this very unpredictable risk of a large award. So the average amount awarded is about 125 million against states. And there's also a very high cost of defending these, and it can cost up to $8 million per party US. And for a lot of developing states, this is a lot of money and problematic. They don't have the kind of lawyers on staff that we do, say, in Canada or in the US. And investors can simply threaten to bring a claim to pressure the host state to abandon reform efforts that might be to address human rights issues or the environment. And all of this makes these host states susceptible to regulatory chill and inaction. And in terms of addressing investor conduct that may violate human rights or cause other harm. So host states, in this way, these IIAs can provide an additional layer of protection for investors, and without excusing states that don't take any action to protect human rights.
Good, thank you. Let's move on to the treaties themselves. Certainly, whether or not you think they're the right instrument, there has been an effort to include some new provisions. I think we've seen a number of treaties that put preconditions on the investor using investor-state dispute settlement. A number of them have included corporate social responsibility clauses. Most of them are basically hortatory type clauses, but they are there. There are a number of other mechanisms that we're seeing that at least go some way towards protecting these other non-economic goals. And the question is, will these be effective? Judge Binnie. I'm sorry, I don't think I'll ever get used to not calling you Judge Binnie. Please go ahead.
Yeah, well, it's, I think, an interesting question. I first of all, in terms of the economic purposes of these investment treaties, I mean, it shouldn't be underestimated. Not all investors are rapacious, multinational corporations. An example of which you, Meg, are very familiar, the Spanish, renewable energy cases. There are dozens of them where a huge amount of money was invested in Spain in renewable energy on the basis of a guaranteed tariff. And once all the investment was made, Spain turned around and chopped the tariff. So a lot of people got stung, and there are a huge number of cases, some going this way, some going that way. But the economic protection is real, and I think even within the magic circle of European states is necessary. I think in terms of incoming investment to Canada, certainly a number of these objectives can be forwarded. Investments in the tar sands, investments in the diamonds in the Northwest Territories, undertakings for the Indigenous people and their interests of the environment. All of this is good, but at the end of the day, I don't think that investment treaties are going to be an effective instrument, because I don't think the political will is there. I look back on the Canadian experience when Ed Broadbent attempted to bring about labor standards in Canadian companies operating abroad. John McKay's effort, I think it was C-35, and the ombudsman. And the ombudsman and McKay was just naming and shaming. There weren't any actual remedies available to counter abuses of human rights or anything else. All they wanted was a mechanism whereby attention could be drawn in Canada to abuses by Canadian corporations outside Canada. And each of these initiatives failed. The ombudsman, under the Trudeau government, which professes this great commitment to human rights, and it wound up having no teeth at all. The ombudsman has no powers to compel evidence, compel testimony, get to the bottom of what's going on in some of these mining disasters, mainly in third world countries. So long as there isn't a level of commitment politically, they're not only not going to do much about Canadian corporations, but I don't think they're going to do a whole lot about insisting on such clauses in investment treaties abroad.
Interesting.
A lot of it is lip service.
Okay. Professor Cote, one of the tools actually that has been incorporated in a number of new treaties is denial of benefits, which you looked at very carefully. Do you have any thoughts in particular on this, but also as well some of the other what I'd call new tools in the treaties?
Well, I think the question is very, very relevant, because let me just go back to one basic feature of international investment law, is that we do not have a multilateral treaty that provides substantive obligations all across the board. We have ICSID convention that provides some procedural common rules, but in terms, that's the main feature. So we have these constellation of 3,000 treaties. And as Tony said, we have these thousands of legacy treaties. So we might innovate in creating new treaties that are very well designed and drafted to deal with these issues. But as long as we still have in force all these other treaties, we are at a risk of seeing corporations use basically corporate strategies to basically evade the nationality of a treaty and elect under a nationality of another more permissive treaty to invest. And that's precisely what denial of benefits clause are designed to fight against, at least to some extent. And that's why I was attracted to study more in detail this tool, because I do think denial of benefit clause are an effective tool to prevent this treaty shopping or abusive treaty shopping. And that can be also to evade the fact that now we have a trend, and that is another, in answering your question, another effective tool potentially is to simply abolish ISDS. We have done it between the US and Canada with CUSMA. I was reading the new investment chapter of the, I don't know in English if you say RCEP or RCEP,
RCEP,
the new agreement signed by China and ASEAN and Japan and Australia, New Zealand, Korea. I mean, very important. And they have abandoned ISDS completely in RCEP. So it's a new trend that is quite now becoming more than just an accident of negotiation. And again, corporate structuring can allow an investor to evade this abolition in ISDS and invest through a corporation that has a nationality of another treaty partner, or of an older treaty that is still existing, because older treaties are not abolished and continue to coexist. So the denial of benefit clause could be effective to fight against that. First, I was quite amazed to realize that only about 10% of treaties have denial of benefit clause.
Not
so
that
it's quite rare, mostly in US and Canadian practice, actually. And beside, and in the Energy Charter Treaty as well, the one that was referring to Justice Binnie with the Spain cases that are brought under that treaty. And what we witness is that there are a lot of problems of conflicting decision on the interpretation of very similar clauses. So there are very, very wide difference. And very, very basic one, for instance, can the clause be invoked by the clause that allows the state facing a claim to say, hey, this corporation is not a real corporation having substantive business activities in the state of incorporation. It is actually owned and controlled by a third country investor with whom I do not have an investment treaty. Therefore, I can deny the benefit of the treaty too. So that's an effective tool. But it is interpreted either as being only prospective, meaning that the host state cannot, once the arbitration proceedings are initiated, cannot invoke the clause. It's too late. It had to do it before. And that's the main interpretation under the Energy Charter Treaty, while under the other cases that dealt with the clause under the US agreement said, no, you can invoke it even during the proceeding, retrospectively. And in fact, it's interesting to note that in the RCEP or RCEP agreement, there is now a footnote in the denial of benefit clause explicitly saying that it can be applied retrospectively. So it is improving in order to be a tool that could be effective. But it is now, I mean, every MIGA regional agreements they all have a denial of benefit clause now. But the problem we have is the older treaties. And if an investor simply invests through a shell corporation, it will basically be able to evade all these new innovative provisions that could be put in investment treaties. So that's the problem that we are facing, and it's going to last for a long time, I think. That's why I would not put all my eggs in the basket of investment, of new innovative investment agreements. I think it's not enough.
Good. Mr. Fontaine, what are your thoughts?
Well, I find the interventions really fascinating. The concepts that are being discussed here are, if I can say this, are quite foreign to a lot of our people. The First Nation community is, as I said, is new to this game, and so we face a real steep learning curve to get up to speed. And what has been helpful in certain situations, and by the way, I agree with Justice Binnie that not all corporate interests are rapacious or are bound and determined to take advantage of our community. But the fact is, we have a tendency here, because I think we still view ourselves as the moral conscience of the world to a large extent. And in doing so, we forget about the situations that actually are troubling in our own country, in terms of how corporate interests generally behave in terms of their investment decisions related to our people, or that impact on our people. Because the fact is, we sit on some of the most valuable land in the entire country. And we really are being forced to learn how to collaborate and to cooperate. And unfortunately, there's one layer there that makes it quite often extremely difficult for investors to invest in First Nation communities. And I'm referring to the Indian Act, this archaic piece of federal legislation. But now there's another layer with UNCTAD, which is, in my view, a very positive development. One of the most positive developments in terms of Indigenous relations with nation states and corporate interests. There, we're faced with ensuring that it isn't incumbent only on our people to learn all about what this means for future investment opportunities for our people, but other interests. And I believe that if we do a far better job of drilling down on what these issues mean for our people that flow from UNCTAD, and I should add the recent case law that speaks very favorably to the rights and interests of Indigenous peoples, that we might be in a far better situation in the near future. And one thing I was going to mention, and you and I talked about this before we started, May. You will recall a few years ago, there were a whole number of our people that were part of trade missions to China.
Yeah.
And the idea of those trade missions was to sell this notion that we had all the land in the country, or some of the best land in the country. We had all kinds of resources, And all we were looking for is investment opportunities. And we thought that China would be more than willing to actually make some significant investments, but that never happened. I still don't know or have an appreciation why we failed in that regard.
Yeah, it's interesting because as you said, China has invested in a number of locations abroad, including in these resource intensive areas. You're quite right. Yeah. Anthony, maybe I should ask you your thoughts on this. Are the changes in treaties going to be effective? Maybe they're not enough, but are they something in the right direction? And we'll get you off of mute.
Yeah, thank you.
There we go.
Yeah, so I think they certainly have I encourage them, and I think that they do have the potential to have some effect. And I think it depends, of course, on the nature of the provisions. I think, if you are going to draft mandatory obligations to meet specific and justiciable obligations related to human rights, or the obligation to obtain free informed consent of Indigenous peoples, or other kinds of obligations, then that is, going to be the most effective way in which to express those obligations. And in the context of investment treaties, as you indicated in your introduction, Meg, one can tie them to the dispute settlement process in the way that you described, such as ensuring that compliance is a precondition of allowing investors to proceed with a claim. Another mechanism, I suppose, would be to allow for counterclaims based on non-compliance with those investor obligations, as counterclaims by the state, where an investor brings a claim. The state would be able to claim against the investor for not complying with the obligations in the treaty. I do think, though, it's important to recognize, at least even with respect to those kinds of strong commitments, there are some inherent limitations on their effectiveness. I mean, one is, while there may be some general incentive to compliance that tying investor standards or investor obligations to the dispute settlement process would produce, the main effect is going to be limited to the circumstances in which investors are actually bringing claims or want to. And that's really only a small fraction of investors. And what we, I think generally should be working toward is a set of thinking about investment rules as ways to contribute to the promotion of these, what you've called non-economic values more generally. And I think there are some ways in which that can be done. I mean, it seems to me that a useful complementary approach might be to incorporate some kinds of cooperation and technical assistance commitments to support the development of transparent and effective regulatory schemes that would encourage and facilitate the implementation and enforcement of these sorts of standards, not just for foreign investors, but also for domestic investors and business people. And I think that I think Penelope is going to address this, but I mean, I think there is the prospect to put in place mechanisms to not only encourage cooperation between states with respect to the development of these sorts of regimes, but also their enforcement, and whether through civil or criminal remedies. And I think it's possible that we could, really seek to promote the development of domestic measures that are conducive to achieving these non-economic objectives in that way. Now, having said that, I appreciate that this is really very far outside what investment treaties have conventionally dealt with. And that's, of course, especially true with respect to bilateral investment treaties. And I actually think that it's highly unlikely that you would ever have this kind of commitment to technical assistance and cooperation in a bilateral investment treaty, in part because those treaties, as they've been traditionally negotiated, are fairly narrowly focused negotiations. On the other hand, what we're seeing increasingly, and Charles Emmanuel mentioned the recent RCEP agreement, we're seeing increasingly that countries are negotiating broad-based, comprehensive treaties that include investment obligations, much more than they are negotiating bilateral investment treaties, although some bilateral investment treaties continue to be negotiated as well. But in the context of these broad-based negotiations, where the parties are trying to create, a kind of broad framework to govern their economic relationship, the prospect for including these kinds of assistance and cooperation provisions, I think, is greatly enhanced. And I'd point, for example, to the partnership agreement between the European Union and the countries of CARIFORUM in the Caribbean as an example of a treaty that actually has a variety of these sorts of technical assistance commitments. They're not as elaborated quite in the way that I've just described, but they do talk about enhancements of labor rights, enhancements of environmental protection and cooperation between the parties to achieve those objectives. So I think that there is, while I'm mindful of Justice Binnie's appropriate caution that we need to think about the political feasibility of all of these things, I think within the context of these broad-based negotiations, there is some prospect for this kind of approach.
Yeah, exactly. One of the sort of very big parts of the success story of Investor-State has been enforcement of obligations, but that is pecuniary obligations. And I think as you bring these other values in, you're going to want to enforce more than just a monetary damage. And that perhaps is another layer of complication, I suspect.
Yeah.
Penelope, what's your thought on this? And we'll mute you as well.
Oh, there we go. Sorry, keep forgetting that part. So I think that there have been a range of changes to different treaties, but they're not always going to be effective the way that they're done. You really need to reimagine the treaties to ensure that they're going to actually be effective in this way. So, for example, if you want to provide for civil liability, you're going to have to provide some standards of conduct for the investors, for example. So I'll just confine my remarks, for example, to the issue of access to an effective remedy for individuals and communities who may have had their human rights violated by an investor or an investment. So you could include a provision that requires both the home and the host state to provide for civil liability of the investors for their role in violations of human rights. And of course, it would need to tackle some of the obstacles that plaintiffs face in bringing these types of claims to the courts. And we've seen that in a lot of the cases that are, coming before Canadian courts, the range of motions that can be brought by corporations in order to have the case dismissed before it gets to trial. So, for example, forum non-convenens, a comity motion or active state, etc. Although now active state, at least in Canada, is no longer a viable motion. So you would need a provision that requires the parties to, first of all, establish appropriate liability for investors, as I said, and then to require the states parties to assume jurisdiction over claims brought by individuals or groups alleging that they've suffered harm resulting from the activity of an investor. And that would address forum non-convenens and comity. You'd also need a provision for active state, except for if it's for Canada, where the state parties agree that the courts of each state will hear claims relating to contributory liability of an investor, even where the primary or co-perpetrator of the harmful acts or omissions is the other states. And these types of provisions would not only remove some of these legal obstacles that make it very hard for these claims to be heard on their merits, but also reduce the costs of bringing these types of cases, this type of litigation. But of course, I guess another issue that plaintiffs will have to tackle, and it's a very problematic issue, is that of separate legal personality. And although it seems, difficult to figure out how to get around this principle, the doctrine of separate legal personality and limited liability, there are jurisdictions and there are different sort of areas of law where they have tried to tackle this. And, you can look, for example, to competition law and the new law of duty of vigilance law that has come out in France. I'll just focus on competition law so that I don't speak for too long. But if you look at EU competition law, multiple entities can be held responsible if they're part of an undertaking that violates EU competition law. And an undertaking includes every entity that's engaged in economic activity, regardless of the legal status of the entity and the way in which it's financed. And in the practice of the European Court of Justice, liability for being part of an undertaking has been limited to parent corporations that control subsidiaries that violate competition law. And there's a rebuttable presumption that a subsidiary and a parent are part of a single undertaking where all or almost all of the shares of the subsidiary are directly or indirectly held by the parent, and the parent can exercise rights to control the subsidiary. Now, the test for control goes beyond legal control, and it looks at whether or not the parent has exercised decisive influence over the conduct of the subsidiary. And all legal entities in the single undertaking can then be held jointly and severally liable. It's a type of enterprise liability. So with that in mind, you could probably formulate a provision in an IAA that would address that problem in relation to civil liability, establishing civil liability or cause of so that individuals and communities can bring claims. So I guess I don't know if I want to go into so much detail, but this could be done by imposing direct civil liability on all the entities within a corporate group. You'd have to define what links are sufficient to connect to the particular entity to the group. And then there would have to be a justification for the liability of entities controlling the subsidiary, and looking at legal control and whether it would create a rebuttable presumption, or would it be better to use decisive influence? And so then you'd probably have to look at, if you're thinking of multinational enterprises that are investors, they have a variety of corporations that may not engage, say, in extractive activity, but will deal with finance, marketing, personnel, research, and development. And so they don't relate directly to the investment. And so you'd have to think, well, should they be considered part of the undertaking for the purposes of this provision?
Yeah.
So I'll leave it.
I go back. So everything you're saying is making me think. I go back to that sort of core question. For example, with all of this, is an investor-state tribunal, currently party appointed in most cases, is that the right mechanism to get into all of these issues? Would you have confidence, if you could change the treaties, that would be the right mechanism?
Oh, this is not in order to create civil liability under the treaty for the purposes of, it's actually requiring states to create civil liability domestically.
Oh, okay, fair enough.
So that you can bring a claim for a violation of human rights by the investor domestically. Yeah.
Okay. Yeah, that's helpful. That's great. Good.
Can I
please,
react?
Yeah, sure.
Because the point you make about the arbitrators that are currently there to hear these cases, and their training and their professional experience and their sensibilities towards these different issues is very critical, I think. Indeed, and again, at the time of the WTO debate, that was one of the points that was raised, that we're not trained in labor law, we're not trained in environmental law, for that matter, and there's a limit to what we can do here. And I would like to build on the comments that were made by Chief Fontaine on UNDRIP, and on there's a case that puzzled me a little bit, is the Bear Creek mining case against Peru, because as far as I know, it is the first case that dealt with these new innovative provision in Canadian treaties, meant to clarify the scope of the notion of indirect expropriation, for instance, etc. And in that case, in fact, there's a reference to UNDRIP in the award, because it involved a native community land where there were mining activities and local opposition to the mining, etc. And in the end, the provisions, the innovative provisions of the Canadian treaty were quite easily dismissed in the analysis by the majority of the arbitral tribunal. And I don't say it means that it will never function, but we have to remember in what setting these innovative provisions are being applied. So on the one hand, it was positive to see that UNDRIP was referred to in an investment arbitration case. In the end, it didn't change anything much to the outcome of the case. So maybe it's slowly percolating, and it does raise the issue. Maybe the traditional trained
investment arbitrators are not super comfortable with getting out of the well-established boundaries of investment law to venture into these new provisions. So that's a point I wanted to make about the point you raised.
Penelope, did you have something you wanted to add there?
Yes, I mean, just to the about, I think it's a very good point about this, but I think, you know, when you're thinking about the changes that need to happen to these treaties, they have to be, you know, you can't make piecemeal changes. And so one of the things that you would, if you were sort of imposing obligations on investors, et cetera, you would have to also require that there was a much more diversified, in terms of experience, set of arbitrators to hear these cases. And if the case concerned, you know, human rights violations, for example, then you would need to have somebody who has some sort of background in that area, and not, you know, and not simply rely on the commercial arbitrators that usually operate in these types of cases as arbitrators.
Yeah, I think I have to, I mean, certainly there are some commercial arbitrators, but I think when you drill down, there are a lot of diverse sets of skills there. I think the problem is having all of the skills you need for that kind of a broad look, if you're bringing in all of these things plus the economic obligations. But point well taken. Let me say I have not yet received any questions. So if anyone in the audience has questions, we certainly have time set aside now for your questions. We're happy to continue here, but I would encourage you to send your questions if you have any, because we would be delighted to answer them. While you're doing that, let me go to one of the next questions, and it's perhaps the flip side. How do you use these kind of instruments that we have now to create better investment into Canada? And when I say better, I know there can be lots of debate about that, but sustainable investment, sustainable energy investment, those kind of things presumably is a good kind of investment that you want to bring in, or investment where you can ensure jobs for people in the local economy. How do you use these instruments to get that kind of a result? Ian, maybe your experience in Tanzania has given you some ideas about that as well.
Well, I think, you know, clearly an investment treaty can perform that function. I'd just like to follow up a couple of points that were made. In terms of the arbitrators, yes, in fact, most of them, I think, are professors of international laws, where they don't really come from the commercial world. They come from the academic world. Secondly, if you've got an arbitration that involves, you know, human rights, labor law, environmental issues, you're not going to find a person who's an expert in all three. So, you know, the idea, which is also inimical to our own judicial system, where the judge is not expected to be an expert in these areas. The judge has to be educated in those areas. So I'm not sure that that is such a problem. I think to me, the real key to this is and it's assisted by what Penelope is talking about, that maybe you can have a treaty which confers jurisdiction on domestic courts, because I think domestic courts is where the answer lies, both for incoming investment and for outgoing investment. All of the doctrines referred to by both Anthony and Penelope, you know, forum non-convenience, the corporate structure, the corporate veil, extraterritoriality, and enterprise risk, these are all judge-created doctrines. And under the common law, maybe different in Quebec with Charles Emmanuel, but under the common law, doctrines the judges made can be unmade by the judges and can be modified. And Nevson is an example where the judges are belatedly, maybe, but they are pushing forward into uncharted territory. I think if there was a treaty that conferred jurisdiction, this would give the courts more comfort in pushing the envelope and breaking down some of these doctrines which are being applied in circumstances where they were never intended. I mean, corporate personality was not intended to block liability within a kind of corporate pyramid. So So these are things the courts can address, and to the extent that modified investment treaties, particularly the multinational treaties, can boost jurisdiction, then it would be very helpful. But I think at the end of the day, the answer lies in the courts.
Interesting. Charles-Emmanuel, do you have any thoughts there?
On the civil law side, I had a discussion recently about the effect of NEFSON in Quebec, whether it was applicable at all or not. And I must say I'm trained, as Justice Binnie said, I'm a good example. I'm trained in civil law, but I'm not a practicing civil lawyer because I'm more, I'm doing international. But well, the judges can definitely change interpretation without changing the law directly. They can change the way they say the law is. And well, laws can be amended by parliaments. So if we decide to, if a treaty, for instance, if we would have a treaty that would say we should do this, as Penelope mentioned, well, we have it. If we look at it, we have it with the Act on crime against humanity, genocide, etc. Well, we had a treaty obligation to organize ourselves that we can try these crimes committed abroad by foreigners if they're on our territory, and we just adopted a law to make that possible, and our courts can judge that. So we could just basically also think that if we have a treaty obligation to make sure that these kind of lawsuits can be done, on the one hand, we can wait for the incremental change of the interpretation by the judges, but we can also legislate if there's a political will to do it. But if we sign a treaty that says that, we should have the political will to implement the treaty we sign.
Yeah. And
I do agree that domestic courts are a good arena for that. I agree with that strongly.
Yeah. Phil, how, from your perspective, how do you bring in what I'm calling better investment, for want of a better term? Are there things to think about here?
Well, I'd use one example of what not to do.
Yeah.
And internationally, my one experience would be the situation in Ecuador, where clearly the courts have been unable to resolve this issue favorably, in spite of a major decision by the Supreme Court of Ecuador that was favorable to the indigenous peoples of the rainforest. And the investment company, of course, took this beyond the Supreme Court of Ecuador and have taken it in different jurisdictions, as have the Ecuadorian indigenous peoples and their council. And it's an incredibly important matter for the indigenous peoples. Their livelihood and has been severely impacted. And there doesn't seem to be a remedy in sight, in spite of believing that the courts was the place to go to resolve this issue. And now the matter is being played out in New York before Justice Kaplan. And the main counsel for the Ecuadorian people has been under house arrest now for months and months and months. So clearly, the courts are not the appropriate place or the best place to resolve such matters. And whether that experience applies to the Canadian situation, maybe not as drastically as that situation, but I mean, there have been, as I noted, the case law in recent years has been really quite favorable to our interests. Has that made a difference in terms of creating investment opportunities for our communities and our people? To some extent, but it's been a very, very slow process. And part of the challenge has to do with land and how the land tenure system is set out and how one defines ownership over our land, right? And it so happens that Canada still has preeminence when it comes to First Nations lands, though that notion is slowly changing to our benefit, but it's a long, slow, arduous process, and it doesn't do anyone any good. Investment community, our people, the country, and there has to be a far better way of resolving these issues.
Yeah, exactly. Tony, did you have any thoughts here?
Yeah, so I think it's probably useful just to talk a little bit about how existing investment treaties work as the context for answering this question about how they can be made to work better. And of course, it's the situation currently is that countries that need investment, as Mr. Binnie described at the outset, agree to provide investor protection based on the assumption that investment protection is actually going to, backed up by investor-state arbitration, is actually going to encourage inward investment into the country. But of course, the way these treaties are set up, that is only an incidental and somewhat uncertain result of providing investor protection. I mean, typically, this may be a bit surprising, there are actually no substantive provisions in investment treaties which actually talk about investment protection. They're all, they talk about investment promotion. They talk about investment protection, and that is to lead to investment occurring. And certainly there's some evidence of a positive relationship between signing an investment treaty and inward investment, but the results of the empirical studies are quite remarkably divergent. I mean, there's a minority of studies that show very little impact, and then the studies that show a positive impact are highly variable in terms of the level of impact. And so I think we're really actually still at a pretty early stage in terms of knowing to what extent these investment protection commitments actually do have a positive effect on attracting investment. And I guess we can, by contrast, the protection guarantees are certain for investors. Although there's some uncertainty about their scope, they certainly operate legally in an effective way, whereas the promise of investment is just, there is no guarantee at all. And that's not surprising because, of course, multinational enterprises make investment decisions based on a wide variety of factors, and an investment treaty is always only going to be one. And how important it is going to depend on the industry and the context. So I guess if that's the baseline, if that's where we are, then how can we do better? Well, I think there are a few ways we could do it. I mean, I think you could have targeted investment promotion provisions that are designed to promote investment through, for example, sharing information between countries about investment opportunities, procedures for investment approvals, relevant laws, incentives that are available, that sort of kind of the whole investment facilitation kind of agenda.
Exactly. Yeah.
I think is certainly one thing that you could address specifically in a treaty. And I think significantly, it's possible to tie that investment promotion agenda to specific social goals. And UNCTAD, for example, has developed a comprehensive list of investment promotion policies that are specifically targeted at achieving the Sustainable Development Goals. So, I mean, it's possible to do this. And again, it's unlikely to happen in conventional BIT negotiations, certainly. But, as we discussed before, if we're talking about broad-based, comprehensive economic cooperation and trade and investment treaties, then, I think that is possible. I'd also note that even in a bilateral context, we see Brazil has negotiated investment promotion and facilitation agreements, which address a lot of the things that I've just talked about. So I think it is something that is politically feasible and that we could do.
Yeah, and as you say, probably that broader instrument of the sort of FTA and something broader that can hold those kind of obligations. Exactly. Yeah. Penelope, do you have some thoughts on this one as well?
Yeah, just some brief thoughts that, Canada has obligations to respect, protect, and fulfill human rights within the territory and with respect to entities that are subject to its jurisdiction, persons and entities that are subject to its jurisdiction. And so they're, having Canada, I guess, negotiating this type of treaty with these reforms in it would be complying with its human rights obligations in doing so. But coupled with that, it also needs to take steps domestically to ensure that that it is respecting, protecting, and fulfilling human rights within its territory. And that meant protecting human rights means it needs to properly regulate incoming investors domestically, and that means putting in place, I guess, certain types of protections that ensure that these investors don't violate human rights, and providing effective remedies domestically. Now, Justice Binnie talked about the failure of the Canadian government to put in place any sort of even a soft mechanism for investigating complaints against Canadian companies that may violate or allegedly violate human rights overseas. But we also don't have anything domestically that really does that. We have to rely, if somebody is subject to the impacts of an investment, we have to rely on different areas in the law, but nothing is really targeted towards respecting human rights that are violated by a corporate entity.
Yeah. Enrique Boone has brought up a good question about the Hague Rules on Business and Human Rights Arbitration. This is an initiative, I think, in about the last 18 months, a year, that's been floated. And his question is, given arbitration requires written consent by parties, is this going to be a useful approach to settle human rights disputes with corporations? And is there a real problem even getting consensus here, especially where corporations don't have obligations imposed on them? Has anybody looked at those rules and thought or had any initial thoughts on how they can be used, or if it's a good tool?
Yes, I have. The problem is that there's no way to finance these arbitrations of human rights issues. It's all very well to set up a mechanism and have rules of procedure and say, the arbitration panel, when installed, is going to have this, that, and the next power. But you've got claimants who are probably not very well heeled against the corporation. Why is the corporation going to sponsor a case against itself? So the problems, I think arbitration would be very useful in that area, but nobody has come up with an answer as to how to finance it.
Yeah, so it's the implementation. Charles-Emmanuel, your thought?
I believe there was at least one or two cases. Unfortunately, I'm not remembering the specifics. I believe it was in Bangladesh with some Western
the textile workers, I think. Yeah.
I think there was a case at least when I suppose the corporation consented to solve the problem and going to arbitration with that. So it can be an interesting tool if the corporation is willing to do it. And I believe, like we said, not all corporations are rapacious, evil doers, and maybe some corporation will be willing, and that's another tool that can be added. So I know there were two instances before these things of where it was experimented. So the idea is building on these cases.
Sure.
What was the real outcome for the complainant, the claimant in that case? I'm not sure about it. At least there was access to some forum to voice their case outside of the domestic jurisdiction. Again, why outside the domestic jurisdiction? That's the question we could ask ourselves again. Why?
Yeah, that's the big thing here. Exactly. What I think we should do maybe is we were going to go for 1 minute takeaways, but how about if I combine the 1 minute takeaways plus one last question, which I'm particularly interested in your thoughts, which is, are the current reform initiatives by international organizations and by governments going in the right direction? And do you think they are too timid? Are they on point? Are they too procedural? I'm just curious what your thoughts are about the directions that are actually ongoing now, because there's a lot happening out there. So let me, in fact, why don't I turn it around in terms of order, and I'll start with Tony, especially because I know you have a class to teach at 2:30. So why don't we get your comments first, and then we'll go back around. Oh, Unmute.
Yeah. Perhaps because I'm speaking first, I should just talk briefly about what is going on, very briefly. So we have a process going on in UNCITRAL Working Group 3 on ISDS reform, which began in 2017. The working group has proceeded very systematically to identify concerns with ISDS and then determine the need for reform. And now that they've decided that there are concerns and there is a need for reform, they are working on what they want to recommend by way of reforms. And they have a very big list of things on their agenda, including an advisory center for state respondents, the creation of a code of conduct for arbitrators, development of an independent appellate body or perhaps a standing court mechanism, reforms to address third-party funding, and so on. I would have to say so far there's been a great deal of discussion and of course no action. And we'll have to see at the end of the day, I think, what comes out of it. I mean, it's quite a challenging process in the sense that it's a very diverse group of countries, both geographically and in terms of levels of development. I've had quite different experiences, I think, with investor-state dispute settlement. And so it's not clear that at the moment, to me at least, that we're going to get out of that group, a strong consensus on the way forward. I guess without wanting to talk about it on the details side any longer, I think it's important to recognize that although the list of items on the agenda is long and each of the items is in itself, I think, important to be thought about, their agenda does not touch on most of the things that we've been talking about today. That is, they've not been talking about issues related to the importance of these other values: sustainable development, the protection of human rights, protection of Indigenous rights, and so on. So it's not about reimagining investment agreements in a fundamental way, to use the language that Penelope used. So I think it's while it's useful, I think the outcome is uncertain, and the agenda, while broad, is still limited, at least from the perspective that we've been looking at investment dispute settlement today. I would say the other sort of major process that's going on, well, it's not really a process per se, but the other major institution, as Meg mentioned at the beginning, is UNCTAD. And it's been really looking at investment issues in really an entirely different way.
Yes.
For quite a number of years, it's been engaged in a significant work program on investment and sustainable development, looking at how not only reforms to investment treaties, but I think much more emphasis on reforms to domestic law and other kinds of international initiatives outside the investment treaty context to figure out or to develop ideas around how we can have investment-led sustainable development. And most recently, they've been focusing on particular kinds of things that can be done to promote the sustainable development goals of the United Nations. And I'd have to say, in that work, investment treaties actually play a relatively small role. In the sense UNCTAD has said that what we need to do is mainstream sustainable development in investment treaties. And some of the things we've been talking about today are ideas about ways to do that. And they certainly have said that investment treaties should not get in the way of state initiatives to promote sustainable development. But overall, without commenting perhaps further on the details in light of the time, I'd say that I think the UNCTAD approach, looking at investment treaties really as part of an integrated package of things that states can do to achieve investment-led sustainable development, is really how we should all be thinking about investment treaties. And maybe I'll leave it at that. Thanks.
Sounds good. Phil, if I can move to you, we've had a question from Marie-Dominique Langlois, and she brings up the example in Guatemala, where we're seeing mining companies suing states for suspending licenses for non-respect of the free, prior, and informed consultation of Indigenous peoples. And I'm not sure if you've had any sort of involvement in this, but the question is, how do you see current debates around this? And how do they involve in international arbitration, and what's going to be the impact in the host state where the investment was located? I don't know if you've been involved in this or if you have any thoughts, but the question to you, and there we go.
You can hear me?
Yes.
Okay, I was going to say that I've had very limited experience in that regard. But domestically, I have a fair bit of experience. And there's been a lot of discussion around arbitration here today in terms of finding appropriate and fair resolution to some very contentious issue. And I had noted in one of my earlier interventions that land is a big challenge, the land tenure system, and what to do with Indigenous lands when investors are anxious to take advantage of certain opportunities. I've come to the conclusion, and this is limited experience, I must admit, that mediation is probably the most elegant way of dealing with these matters, these very contentious issues. It's non-adversarial, and it engages the parties that are part of the conflict or the problem in a way that, for example, litigation can't. And so my preferred approach to resolving these major issues is through mediation.
Yeah, I think that's a really good point, because Investor-State is just on the cusp of, can we use mediation? So the view of someone who's seen it and seen it work is really useful. Thank you. I think that we have come to the end of our time. There are no end of questions or thoughts, but Una, how about if I pass it over to you to conclude?
Okay, well, thank you very much, Meg. You've done a wonderful job of moderating this panel. And I'd also really like to thank the amazing panelists that we've had today. Mr. Ian Binnie, Professor Penelope Simons, Professor Tony Van Duzer, and Professor Charles-Emmanuel Cote, as well as Mr. Phil Fontaine. You've really shed a lot of light on this very complex issue of international investment and dispute settlement. I'd also like to thank the panelists, the participants, for joining us for this important discussion and for posing some great questions. Finally, I'd like to thank the Human Rights Research and Education Center at the University of Ottawa and the Center for International Governance Innovation for sponsoring this series. And this brings to an end a 4-part series that we held on the book. And you'll be pleased to know that you can review the recordings, and of course you can share it with your friends. The recordings will be available on CG and HREC's websites on December the 2nd. So I hope you enjoyed this panel and that you will enjoy the book, Corporate Citizen. The link to purchase it is available here and at CG and on the McGill Queen's website. So thanks everybody. It was great to see you, and all the best.